does one deal with a problem in conflict of laws? First, determine whether the court has jurisdiction over the case. If it has no jurisdiction, the case should be dismissed on that ground. If it has jurisdiction, the court will determine whether it should assume jurisdiction over the case or dismiss it on the ground of forum non-conveniens. Of course, it is the law of the forum that determines whether the court has jurisdiction or not over the case. Once the court has determined whether it has jurisdiction over the case, it will next determine whether to apply the internal law of the forum or the proper foreign law, considering the attendant circumstances. How does the court determine whether it has jurisdiction over the case? There are three kinds of jurisdiction: jurisdiction over the subject matter, jurisdiction over the person, and jurisdiction over the rest. Jurisdiction over the subject matter. Jurisdiction over the subject matter is conferred by law and is defined as the power to hear and determine cases of the general class to which the proceedings in question belong. Since jurisdiction over the subject is conferred by law, it cannot be conferred by consent of the parties or by their voluntary submission. In the Philippines, jurisdiction over the subject matter is found in the Constitution and the Judiciary Reorganization Act. Since jurisdiction over the subject matter exists only in the abstract, it must be invoked by filing the proper complaint or petition with the court. And it is the allegations of the complaint or petition read in the light of the proper jurisdictional law that confer jurisdiction on the court. If the allegations of the complaint show prima facie a lack of jurisdiction, the court must dismiss the case outright. No preliminary hearing on the evidence is needed. If, on the other hand, the complaint or petition on its face shows the presence of jurisdiction, trial must be held. Should the evidence show that the court really has no jurisdiction, the case must be dismissed. In the realm of conflict of laws, however, there is another element which the court must consider in determining the matter of jurisdiction: the possible enforceability of its decision in foreign states, subject to the rights of said states. This is because in conflict of laws, jurisdiction is the power of the court of the forum to render a decision that will create legal rights and interests which other states will recognize and enforce. Jurisdiction over the person. Jurisdiction over the person is the competence or power of a court to render a judgment that will bind the parties involved, the plaintiff or petitioner, and the defendant or respondent. Jurisdiction over the plaintiff is acquired the moment he invokes the power of the court by instituting the action by the proper pleading. A plaintiff, under the rule of submission, may sometimes, by filing suit with the court, be deemed to consent to its exercise of jurisdiction over his original cause of action, including counterclaims filed by the defendant, and he would then be subject to the judgment of the court. Jurisdiction over the defendant is acquired when he enters his appearance or by the coercive power of legal process exerted by the court over him. His personal appearance by counsel is tantamount to his giving consent to the court's exercise of jurisdiction over his person, except if his appearance or that of counsel is for the sole purpose of questioning the jurisdiction of the court. Jurisdiction over the defendant may be acquired through his voluntary appearance or by personal or substituted service of summons on him under the rules of court. This is referred to as the coercive process in the manner provided by law. In personal service, whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person, or, if he refuses to receive and sign for it, by tendering it to him. In substituted service, it may be effected by leaving a copy of the summon at the defendant's residence with some persons of suitable age and discretion then residing therein, or by leaving the copy at the defendant's office or regular place of business with some competent person in charge thereof. Strict compliance is required before the court can acquire jurisdiction over the person of the defendant. Thus, service on a 12-year-old daughter of the defendant is not valid substituted service because of the child's lack of suitable age and discretion. However, the question of erroneous service of summons must be raised before judgment is rendered, or this would be a clear case of waiver. Moreover, Defective service may be cured by actual receipt of the summons by the defendant, or if in any other manner knowledge of the existence of the case should come to his attention.
Jurisdiction over the res. Jurisdiction over the res or thing is jurisdiction over the particular subject matter in controversy, regardless of the persons who may be interested therein. The basis of the exercise of this jurisdiction is the presence of the property within the territorial jurisdiction of the forum, even though the court may not have the personal jurisdiction over the persons whose interests in the property are affected. This is because the purpose of the suit is not to impose a personal liability on anyone, but it is to affect the interests of all persons in a thing. Examples are land registration cases and admiralty cases, where the purpose is for the judgment to bind the whole world insofar as the subject land or vessel is concerned, and not just the interests of specific persons. This kind of jurisdiction is referred to as jurisdiction in rem, as distinguished from jurisdiction in personam, which binds only the parties and their successors in interest. What about actions quasi in rem? In an action quasi in rem, the purpose is neither to impose a personal liability in a thing, nor to affect the interests of all persons in a thing, but to affect the interests of particular persons in a thing. In such case, the court may render a valid judgment when it has jurisdiction over the specific res and the particular persons whose interests are affected. Examples are foreclosure of a mortgage, partition of land, or an action to quiet title to property. An action affecting the personal status of the plaintiff is also classified as an action quasi in rem. In actions quasi in rem, or those involving the personal status of the plaintiff, extra-territorial service of summons by publication is allowed.
How may service of summons be affected? In actions in personam, service of summons may be by personal service or substituted service. Service by publication would not be sufficient whether the defendant is in the Philippines or not. When then is service by publication allowed? Summons by publication is authorized only in three cases. First, if the action is in rem. Second, if the action is quasi in rem. Or third, if the action involves the personal status of the plaintiff. When may extraterritorial service of summons be effected? There are four instances wherein extraterritorial service of summons may be made. First, when the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff. Second, when the defendant does not reside and is not found in the Philippines, and the action relates to or the subject of which is property within the Philippines, real or personal, in which the defendant has a claim, a lien, or interest, actual or contingent. When the defendant is a non-resident, but the subject of the action is property located in the Philippines, in which the relief demanded consists wholly or in part in excluding the defendant from any interest therein. And lastly, when property of a non-resident defendant has been attached in the Philippines. In the last case, however, while a writ of attachment may be issued by the court upon application, said writ cannot be implemented until the court has acquired jurisdiction over the non-resident defendant, for without jurisdiction, the court has no power and authority to act in any manner against the defendant, and any court order to that effect will not bind said defendant. How may extraterritorial service be affected? Such service may, by leave of court, be affected by personal service, by publication, but copy of the summons and the order of the court must be sent by registered mail to the defendant's last known address, and in any other manner that the court may deem sufficient, for example, by registered mail. Here are illustrative cases on the problem of jurisdiction. Mar, a Filipino permanent resident of California, USA, came to the Philippines on vacation. While here, he had an affair with an impregnated Rose. Learning of Rose's pregnancy, Mar took the first available plane to the US. If after the birth of her child, Rose files an action against Mar, who happens to have some properties in the Philippines, for recognition of her child with support, would the action prosper, summons having been served on Mar only by publication? Answer. As to the recognition of Rose's baby, yes, because that is an action that affects the status of the child, so that summons by publication would be sufficient for the court to acquire jurisdiction over Mar. But the demand for support of the child against Mar will not prosper, because it would be a judgment in personam, and summons by publication would not give the court jurisdiction over Mar. Let us take a look at this next scenario. Joe, a Filipino non-resident, married Susan in the Philippines while on a short vacation here, without revealing to Susan that he is already a married man. After Joe's departure for his foreign residence, Susan filed against him an action for the declaration of nullity of their marriage and damages, as Joe happens to have some properties here. Upon filing of her petition, Susan also asked the court for a writ of preliminary attachment against some of Joe's properties in this country. Would Susan's action for declaration of nullity and damages against Joe prosper, summons having been served on the latter by publication? Answer. For the declaration of nullity of marriage, yes, because that asks for a declaration of the personal status of Susan, equivalent to an action quasi in rem. But as to the demand for damages with a writ of preliminary attachment, while the court could issue said writ, it cannot be implemented until the court has acquired jurisdiction over the non-resident defendant, which can be done only by personal or substituted service of summons on the latter, because a judgment for damages is a judgment in personam. Here is our next scenario. X, creditor of Y, a resident of Spain, filed an action against Y for the foreclosure of mortgage over a property given to him by Y as security for the payment of a debt contracted by Y while he was in the Philippines. In his action, X also prayed for deficiency judgment in case the property mortgaged would not be sufficient to satisfy the debt. Again, summons was served on Y by publication. Would the action prosper? Answer. As to the foreclosure of mortgage, yes, because it is an action quasi in rem. But as to the demand for deficiency judgment, no, because it is asking for a judgment in personam against Y. What are other points to remember on the matter of jurisdiction? Once the plaintiff files an action before a Philippine court, whether he be a Filipino citizen or a foreigner, a resident or non-resident of the Philippines, he submits himself to the jurisdiction of the court and puts the judicial machinery into action. Hence, he is now subject to any counterclaims or cross-claims that the defendant may put up under Philippine law. In choosing a particular forum, the plaintiff has accepted the entire judicial machinery of the forum completely, so that he must accept not only its benefits, but its burdens as well. As for the defendant, he becomes subject to the court's jurisdiction as to all subsequent matters in the same suit, like appeals. And even if he leaves the state of the forum prior to the final determination of the action against him, jurisdiction of the court over him continues. Explain why the court may refuse to exercise jurisdiction over a case on the basis of the principle of forum non-conveniens. As has been said before, even if the court has jurisdiction over a conflicts case, it may, by invoking the principle of forum non-conveniens, refuse to exercise or assume that jurisdiction in view of any of the following practical reasons. 1. The evidence and the witnesses may not be readily available in the forum. 2. The court dockets of the forum may already be clogged, so that to permit additional cases would hamper the speedy administration of justice. 3. The belief that the matter can be better tried and decided in another jurisdiction, either because the main aspects of the case transpired there or the material witnesses have their residence there. 4. To curb the evils of forum shopping. For example, the non-resident plaintiff might have filed the case in the forum merely to secure procedural advantages or to annoy or harass the defendant. 5. The forum has no particular interest in the case, parties not being citizens of the forum or residents elsewhere, or the subject matter of the case evolved somewhere else. 6. Other courts are open and the case may be better tried in said courts. 7. The inadequacy of local judicial machinery for effectuating the right sought to be enforced by the plaintiff. 8. The difficulty of ascertaining the foreign law applicable. For example, several German citizens brought insurance claims against the New York Life Insurance Corporation on insurance policies issued in Germany. Although the plaintiffs were citizens and residents of Germany and defendant was a New York corporation, suit was brought in Oregon, USA, where defendant had an agent on whom summons was served. May the Oregon court, in the exercise of its discretion, refuse to take cognizance of the case? Answer: yes, on the ground of forum non-conveniens, because, first, both parties were non-residents of the forum. Second, the courts of Germany and New York are open and functioning, and service can be made on the defendant in either jurisdiction. Third, to require defendant to defend action in the forum would impose upon it great and unnecessary inconvenience and compel it to produce records and papers which were of daily use in its current business. And fourth, the case could consume months of the time of the court, resulting in delay, inconvenience, and expense to other litigants who are entitled to invoke the court's jurisdiction. Remember, however, that the doctrine should generally apply only if the defendant is a corporation. For if the defendant is an individual, the proper forum may not be able to acquire jurisdiction over him. For example, he might not be residing there, thus leaving the plaintiff without any remedy. After the court has acquired jurisdiction over a conflicts case and has decided to assume that jurisdiction, when is it bound to apply the internal or domestic law? There are at least 3 instances when the forum has to apply the internal or domestic law in deciding a case in conflicts of law. First, when the law of the forum expressly so provides in its conflicts rules. Second, when the proper foreign law has not been properly pleaded and proved. Third, when the case involves any of the exceptions to the application of the proper foreign law. Give examples of cases which require the application of Philippine internal or domestic law. Whenever land involved in the suit is located in the Philippines, Philippine law or the lex situs is applied. Regarding the property relations of the spouses, Article 80 of the Family Code provides that in the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by the Philippine law, regardless of the place of the celebration of the marriage and their residence. The only exception is when both spouses are aliens. When a Filipino father with American children, who became such under the rule of jus soli, dies, his succession shall be governed by the Philippine law. If a will executed by an alien abroad is revoked in our country, the revocation must comply with the formalities of Philippine law. Explain why the foreign law cannot be applied if it has not been pleaded and proved. This is the second case where the internal or domestic law of the forum will be applied. That is, when the proper foreign law has not been properly pleaded and proved. The reason is that our courts cannot take judicial notice of foreign laws, so that if the proper foreign law is not pleaded in the complaint or petition or in the answer or any other responsive pleading and is not proven as a fact, the court has the right to presume that the applicable foreign law is the same as the internal or domestic law of the forum and should therefore apply the latter law. So, how is a foreign law proved under our rules of court? If the law is written, it may be proved by an official publication thereof, or a copy of the law attested by the officer having legal custody of the record, or by his deputy, accompanied by a certificate of any Philippine embassy, consular, or foreign service officer in the foreign country where the record is kept, and authenticated by the seal of his office. If the law is unwritten, It may be proved by the oral testimony of expert witnesses or by printed and published books of reports of decisions of the country involved if proved to be commonly admitted in its courts. What is meant by the processual presumption of law? This rule means that when the proper foreign law has not been properly proved, the court of the forum may presume that said foreign law is the same as its local or domestic law, which it can now apply. How is a foreign law that has been duly pleaded and proved to be interpreted by our courts? As a general rule, a foreign law that has been duly pleaded and proved should be given by our courts the same interpretation as that given by the foreign tribunals of the country where the law comes from. A possible exception is a case where somewhere in our laws there is a statute worded identically as the foreign law, so that our courts cannot be blamed if they disregard the foreign interpretation of said foreign law and give it the same interpretation previously given by our courts. When a case involves any of the exceptions to the application of a foreign law, the rule is that the foreign law cannot be applied and the courts should instead apply the domestic or local law. What are these exceptions? First, when the application of the foreign law would run counter to a sound and established public policy of the forum. For example, we cannot enforce in this country a divorce of a foreign country if the parties are Filipinos. If, however, the parties are a Filipino and a foreigner, and the latter validly obtains a divorce abroad, capacitating him or her to remarry, the Filipino spouse can also marry again. Also, a joint will executed by Filipinos locally or in a foreign country is not valid. And finally, incestuous marriages under the family code and those considered void by the code by reason of public policy are null and void, even if they are valid in other countries. However, these provisions apply only to Filipinos. Second, when the foreign law is contrary to the almost universally considered principles of morality, or contra bonos mores. For example, foreign laws recognizing prostitution, agreements under foreign laws that corrupt the proper administration of justice or reward crimes, contracts under foreign laws to corrupt public officials, and in general, all transactions that infringe on good morality as understood by the forum and those inconsistent with the best interest of its people. Third, when the foreign law involves procedural matters, there are no vested rights in rules of procedure. Hence, a party to an action must submit himself to the procedural formalities of the forum, except when the law is both procedural and substantive, like the rules on prescription and the statute of frauds. Hence, an American cannot insist on a jury trial in the Philippines. Neither can he insist in the application of American procedural laws in a case in the Philippines where he is a party. Fourth, when the foreign law is penal in character, crimes committed in foreign countries are violations of penal laws of those countries and cannot be prosecuted here, especially as we follow the principle of territoriality in criminal law. A penal clause in a contract entered into abroad may, however, be enforced here because such clause is not criminal in nature but only provides for liquidated damages. Fifth, when the law is purely fiscal, for example, revenue producing, or administrative in nature, we are not bound to enforce foreign revenue or administrative laws. We are not concerned with the collection of taxes by foreign countries or with foreign laws relating to governmental functions or matters. Sixth, when the foreign law might work undeniable injustice to the citizens or residents of the forum. Foreign laws that would result or cause injustice to citizens or residents of our country should not be enforced or given effect here. An example is a foreign law putting the age of majority at 21 and refusing to recognize contracts of Filipinos abroad who are above 18 but below 21, considering that the age of majority in our country is 18. Also, foreign divorce laws in cases where the divorces were obtained by Filipinos. Seventh, when the application of the foreign law would endanger the vital interests of the state. The national interests and security of our country should not be jeopardized by foreign laws, nor should we enforce foreign laws that undermine our governmental processes. Eighth, when the case involves real or personal property located in our country. Remember that we apply the lex situs or lex recite to all properties, whether real or personal, found or located in the Philippines. This is based on Article 16 of the new Civil Code.